Our next argument will be in re Ferranti.
Wow. You were here for that last case.
Oh, okay. No, I didn't know this either. Yeah, I didn't know this either. Yeah. No, but it's funny. I didn't know that. That's a lot of
Mr. Sankaran.
Good afternoon, Your Honor, and may it please the Court. My name is Vivek Sankaran. I'm here on behalf of Michael and Susan Ferranti. I'd like to reserve just 2 minutes of my time for rebuttal, and I'd be happy to entertain questions at any point and waive my free-fire period. The key errors in this case are largely undisputed. One, that the trial court accepted an adjudication plea without advising my clients of any of the procedural rights they were waiving. Two, that the trial court exceeded its statutory authority by committing 2 separate acts, one becoming a witness in these proceedings and visiting the home himself on the key disputed issue in this case, and third, by conducting an in-chambers interview of a child at the conclusion of the termination of parental rights hearing, even though neither the juvenile code nor the court rules empower the trial court to do that. This happened in a case which the trial court itself described was a close case, in part because this child's siblings were still living at the home. The child had unsupervised visits almost until the filing of the petition to terminate parental rights. And the court itself said this was not the ordinary termination of parental rights case. But the core issue in this case is about the scope of appellate review and what types of errors this court can review. And I'd like to start with the biggest issue before the court, which is what to do with In re Hatcher. I think this is the 4th time that we've been here discussing In re Hatcher in the last 5 years. And it's one that continues to perplex the Court of Appeals as well. There have been at least 10 decisions before this court and the Court of Appeals in which both courts have overlooked Hatcher to address key adjudicatory errors. And I want to make sure my position...
Would you identify a single one of those decisions in which there was an allowance of a collateral appeal in a Hatcher case? You indicated there were 10 cases?
They were, and all of them allowed the collateral attack to proceed. It's In re Sanders, In re Mays.
Sanders was a single-parent case, wasn't it?
It was a single-parent
case. And that
case.
single parent had never been afforded an opportunity to appeal, to even have their case heard. Is that right?
So I would disagree with that.
How is that a collateral appeal? Explain that to me.
Certainly. So in Sanders, the parent, even though he was not a respondent, was a party to the proceeding and had counsel throughout the beginning of the case as well. But I'd like to actually just get to the heart of the issue and to clarify sort of my position.
Okay, but I just want to suggest that there's not quite as many cases as you're suggesting in which we've run afoul of Hatcher and we've allowed a collateral appeal. I mean, I think there have been some difficult cases that the courts had to grapple with, but I think by and large Hatcher's been respected over some extended period of time by this court. That's my only proposition here.
Certainly, and I say that just to point out that at the Court of Appeals, within the last 2 years, there have been at least 4 cases where the Court of Appeals, many of them some of them are pending before this court as well, In re Guido Seguer, In re Alston, In re Collier, unpublished decisions where the court got to the key adjudicatory error. My position here is not that a child protective system which requires parents to appeal an adjudication would be the wrong policy choice. In fact, I think that we could craft a court rule that makes it clear that puts people on notice.
I'm glad you raised that. I don't mean to interrupt you again, but I hope you'll forbear with me. Wouldn't it be a relatively easy solution to the problem that you've identified here, a legitimate concern about affording due process to a parent whose rights are on the verge or in jeopardy of being terminated. I absolutely agree that such a person is fully entitled to due process. But what would be wrong with a simple amendment of our court rules to require the trial court to inform parents during the adjudication stage, 1, at the plea hearing, 2nd, at the adjudication trial, 3rd, when an initial order of disposition following adjudication is entered, 4, a dispositional order placing a minor under supervision of the court, and 5, removing the minor from the respondent's home, or on all 5 or 6 of those occasions, that there is an appellate right, and if that a right to be informed of an appeal, and if that appeal is not that information is not provided to the individual, there will be a right to an appeal. What's wrong with saying on 1, 2, 3, 4, 5, 6 occasions, we are going to remind the parties and we're going to remind the judge that there is an obligation to inform the parent of the appellate rights that attach to this process?
Absolutely nothing, Your Honor. I mean, I would embrace such a proposal.
Would it fully address the concerns that you have in this case if such a modification of the court rules would be?
With a tweak, making sure that there's also a right to counsel that attaches to that, which I think with those tweaks, if you informed clients that they have the right to appeal it and the right to counsel, which would mean the right to transcripts as well, I think that would satisfy my concerns with the current system, in which I think one of the reasons this court is seeing these recurring issues is because people are unknowingly waiving a right that they don't even know they can waive.
And as you know, that would also satisfy the concerns of other participants in the system, that children not have to go through this process repetitively and have to endure another 2 or 3 years during which the whole system is goes through these questions and these procedures.
Mr. Sinker, we are going to let you talk eventually, but let me pile on. We might. We haven't decided yet. First of all, welcome to Groundhog Day. I believe you represent children sometimes as well. You're not.
I do, and that's why most of my work at the trial court is on behalf of kids, and so I want to make sure the court. I'm sympathetic to many of the policy concerns.
I apologize for interrupting you twice.
No, please
I appreciate your forbearance here.
It gets to the heart of the issue, though, which I think is important. That in terms of of that type of proposal, I think that's exactly the direction this court needs to go. That's just not the reality on the ground right now, where in many counties, so I think the SCAO forms are indicative of this. There's no right to appeal form that even exists as it relates to an adjudication or dispositional order, in contrast to the termination stage, where it's very clearly laid out. And I would challenge the court, if you talk to the Court of Appeals, I would suspect that so I've been in Michigan since 2005. In my 13 years here, I could probably count on one hand the number of adjudication appeals there have been to the Court of Appeals. There's a reason why this court rarely sees, if any, adjudication appeals, is that it's just not a right that the court never has to inform litigants that they have a right to this appeal. If you look at our court rules, it actually doesn't mention at all the word adjudication in the section of the court rules that has to do with appeals. What Hatcher did was made a bunch of assumptions about the process, which don't bear out in the way that our statute and court rules are constructed, which is why I welcome, Your Honor, the suggestion that you have as to how we fix the mess that we're in.
Do we need to fix Hatcher and then fix the court rules, or can we do it all together? Is there like a way to? If we gave you a robe and put you up here, what would you do?
I would reverse Hatcher and open up a file immediately to fix the court rule to address the notice issues, which would create the same world that Hatcher wanted, which is we don't want adjudication appeal. It's not good for the parents I represent to have an adjudicatory error 2 years later, and then we have to go back in time. They haven't seen their children in over a year as this appeal goes through. The one amendment, Your Honor, that I'd make to your suggestion is to expedite the appellate process as it relates to the adjudicatory appeal. Because right now, even, Sanders is a good example. It took over a year to work that case through the court system. We have to come up with a way in these child welfare appeals to get briefing and the transcripts done in a short time, especially as it relates to these interim decisions. Because if not, I can tell you from cases where I've had appeals pending while we have trial court proceedings going on, things are largely at a standstill. And the problem is the adjudication time. Assume a parent has been adjudicated. That's the time where everyone needs to be sort of cooperatively working together on a reunification plan. And so to the extent that there are any errors that are claimed, I would really push this court to expedite that process, if that's at all
I
possible.
know this is not an administrative hearing. This is a case or controversy that we have before us, but what was the other concern you communicated earlier about the right to counsel?
Well, to make sure that the parent has a right to appellate counsel to navigate that process.
Okay.
And right now it is clear that many counties in Michigan do not read the rules as requiring that, in part because the rules don't say it. They don't actually require that, whereas for a termination of parental rights appeal, it is clear. And so bringing it back to the case in controversy before the court, I think all of these issues are related, which is, as a policy matter, I don't disagree at all with many of the voices that I'm hearing.
Of course, the flip side of that, too, is that if they don't ultimately challenge the adjudication at an appropriate point, they won't be able to challenge it after their parental rights have later been terminated.
I agree. Yeah, I agree. I mean, I think that with that level of clarity, I think, in the briefing, especially with the Attorney General's amicus brief, many of the cases they cited in the criminal context, if we had that sort of clarity about how to set aside a plea and when you could appeal what, as a rules and process guy, which is what I want to bring to our system, so we have clarity and everyone is on notice, I would put that in the court rule, which is if you don't raise an issue with a plea, you don't raise an issue with an adjudication, then you can't challenge that later on. And that is a world that I would embrace, but it's not the world that my clients experienced in this particular case. And what I hear from clients, both in this case and others, is I didn't know when I could appeal what type of decision. And that's the level of clarity.
Weren't they represented? They waited nearly 2 years in this case to appeal.
They were certainly represented, but I would push back, Your Honor, the same lack of clarity that exists for parents also exists for lawyers, which is if you open up the court rules and you look at the statutes, let's assume for the sake of argument that the lawyer said you have to appeal this, which I think is ambiguous to begin with. In most counties, then the parents would be forced to navigate this process on their own because, again, there's no right to counsel, there's no right to transcripts, and we just haven't set up the infrastructure in place to guide folks about what their rights are and when. And that's really the core issue. It's not an issue I think I wholeheartedly agree with the court rule and the world that you want, which is early decisions, appeal them right away, and it benefits everybody. But that's not the clarity that we currently have, and that's why I would ask the court to reverse Hatcher, and then let's fix this. And I think that looking at the AG's brief, me and Mr. Rasucia, we agree in large part on where the system needs to go, and that's my argument as to why. For the current cases going through this process, I don't think it would take very long, nor do I think it would be very difficult in terms of wordsmithing the fix. But for the current clients going through the pipeline, that is the problem with Henry Hatcher.
No, I was going to. Going back to the larger doctrinal, if a majority of this court were to agree with you that Hatcher, or be willing to say that we agree with you that Hatcher is doctrinally problematic, the other appellate rules that limit appeals would still work. I mean, forfeiture, waiver. You would agree that your clients, not in this case in particular, but parents would be subject to all of those regular rules of appellate practice, correct?
Certainly, and so this would be reviewed under a plain error standard because it wasn't preserved down below. So in the interim, that could happen. The other approach that this court has taken in the adoption context is this court could, in a decision, outline the framework of what it wants the rule to be, which would be binding moving forward. So we don't have the interim stage of waiting for a court rule to develop while instructing those in the field to do this. I think that, for example, in this sort of the ruling that an adoption can't be finalized before a termination appeal is exhausted, in a short order in this court changed practice to make sure, in a case called Henry Jackson, to make sure that courts weren't doing that. And it didn't wait for the court rule process to unfold. And so certainly that option exists as well. I don't think that the other two issues are much more straightforward in this case in terms of the briefing and the error. I think that juvenile courts are courts of limited authority. The legislature and court rules dictate what courts can do and how they can do it. There's absolutely no authority for a court to become a witness and visit a home. There's absolutely no authority under our on the juvenile code to interview a child in chambers, unlike a child custody case. If you look at the juvenile code, the code explicitly talks about what protections are available for child witnesses in terms of a support person, video recorded deposition. There are mechanisms the legislature has included not interviewing a child in chambers. And so independent of the Hatcher argument, those are two separate issues that
That's
I think...
a tough one, though. I mean, I hear what you're saying, but that is a tough one. I was struggling with that one myself. You know, the idea that sometimes a child, you know, a lot of times, it's a tough one. I'm just saying I have been really having a hard time with that one because sometimes the child would like to talk to the judge and have that kind of interpersonal communication with the judge. And that's a tough one. You know, a lot of times, you know, when you're trying to, as a judge, when you're trying to appreciate someone's veracity or someone's sincerity or their genuineness or their energy or those kind of elements, you need to sometimes have that one-on-one. It really does make a difference. I understand your position. I'm just saying it's not as easy.
Your Honor, may I just quickly respond to
Please.
Justice Bernstein's
Please
point?
do.
As a policy matter, I don't disagree with you. And I actually think that many states across the country in their juvenile court systems have created mechanisms with a transcript, with a record, with parties proposing questions for the judge to ask a child questions. Neither our legislature nor our court rules have afforded and created that ability for juvenile court judges to do that.
Right.
I'd welcome an opportunity to have that conversation about how we do that in a fair way, but we just haven't done that yet.
Okay.
Again, I'm sorry to waylay you, but you have to acknowledge that you did open up the issue in talking about
And I want to make
administrative
clear that I'm happy to talk about it, Justice.
Okay.
Thank you.
Any further questions? Thank you very much.
Thank you, Your Honor. May it please the court. My name is Amanda Brooker, appearing on behalf of the Department of Health and Human Services. Seated at council table is Eric Restuccia of the Attorney General's Office, who has reserved some time to speak to the court. And also seated at council table is David Delaney, who is guardian ad litem in this case. Obviously, the court has heard various arguments about Hatcher over the years. I'm open to the court asking me any questions on any of the particular issues at all. Just touching on Hatcher, and the issue that Chief Justice Markman brought up about amending the court rule, I think that would be a perfect way to address this issue so that trial courts and the attorneys and the parties are all aware of that ability to appeal that initial adjudication ruling. When we're looking at all the other court rules and statutes involving child protective proceedings, they all seem to indicate that time is of the essence and reflect the fact that finality and permanence is the utmost goal in these cases. You know, the court rules have the time limits right spelled out about when we have to have a preliminary hearing, when we have to have an adjudication hearing, when we have to have a dispositional hearing. So it would only make sense for the court rule to spell out that the parents would need to appeal that initial adjudication order at the time. Bringing it back down to the specific facts in the case before the court right now, at the initial preliminary hearing on October 29th, 2015, the parties were advised of their initial rights, and the court immediately appointed counsel. Between October 29th, 2015 and December 21st, 2015, which is the date that they entered their plea, we had 4 hearings. We had a contested preliminary hearing. They were represented by counsel at each and every one of those hearings who vigorously defended their rights. And what's especially interesting in this case is the day that they entered the plea, December 21st, 2015, was actually the day that we were set for trial. So they could have gone forth and had the trial that day, but they chose to enter a plea. And looking forth as well, you know, I think the court is very well aware of the issues with Hatcher, the concerns with timelines, the concerns when we have a child who's been in foster care or in a relative placement, which may be from 18 to 20 months, you know, between the time that we have that termination decision and the time that it goes up through the Court of Appeals. In my experience, it's taken probably 8 or 9 months from the time we get a termination order and the time that the case works all the way through the Court of Appeals and we get that order that either reverses or affirms the trial court's order. So that causes, you know, additional concerns if the court were not to follow Hatcher in this case. If we, you know, when we go back and examine the issue of whether we're going to whether we have to have a new adjudication if we're 2 years or 3 years out. We may have witnesses who are unavailable. We may have witnesses whose memories are a little bit foggy. We may even have witnesses, that we just can't find or we're reluctant to testify just given that passage of time. And especially during these cases as well, some trial courts do suspend parenting time when they are pending that termination petition. So that's also a concern as well when you have a child who's in a foster care placement and maybe bonding with that other caregiver. Just briefly to touch on the two other issues, which again I think probably aren't what the court's looking at as much as the Hatcher issue, but are still things that the court did. We admitted, in our briefs that was error for the court to do either of those things, to either visit the home or to interview the child. But what makes it a little bit different is that when we're looking at the interview of the child, that was something that the parents' attorneys both requested numerous times throughout the case. And the trial court even stated that he would not do that if any of the parties had objected. And that's a little different from the HRC case, which determined that the court could not interview children at all in that case, because in that case, the judge did not give the parties a chance to object and didn't even give them really a chance to acquiesce to that at all. Either party could have called the child as a witness at our termination hearing. The parents did not. We did not as well. And I know that causes difficulties. I have the same concerns that Justice Bernstein has about, children having to be brought in and be interviewed on the record in these cases. And it's just a concern that we have as well. As far as the home visit, there was both parents were told that they were able to supplement or provide any additional information after that home visit through testimony. They could have done that. They both testified at the termination trial. In addition, there were caseworkers that testified about the conditions of the home, and they were able to do that as well. So we would just ask the court to find, although that was error, that did not affect their substantial rights.
So what is the upshot of the two errors that you acknowledge? What is the upshot for this particular case and the two errors that you acknowledge here?
I wouldn't ask the court to do anything, to change anything in terms of the case law and the laws that are out there. We would just ask the court to make that determination that it was an error, but it didn't affect their substantial rights, just given the overwhelming evidence that was presented at the termination hearing and all the other testimony that was provided as well. Are there any other questions?
No, thank you very much. Mr. Restuccia, you have 5 minutes, I believe.
Thank you, Your Honor. May it please the court, good afternoon. Eric Restuccia from the Attorney General's office, appearing on behalf of the Attorney General as amicus. This is a kind of a redo of the In re Hill case that we had, that was presented to this court within the last 2 years. The same three questions presented in this case were the identical questions asked in In re Hill, and of course all of the bench really has weighed in on the question of In re Hatcher, except for the newest of the justices. So in a way, this seems like the question of In re Hatcher may be particularly suited for one of the justices to review. I think from hearing what Mr. Sankaran has described, there's a lot of agreement between the Attorney General, the Department, and the parents in this case. I think an amendment to the court rules would be a helpful guidance to the bench and bar. Mr. Sankaran has made the representation that a lot of the circuit courts are operating, or I should say family courts throughout the state are operating in a different fashion, and that may well be true. My reading of the court rules seems to be clear that you have a right to take an appeal under 3993 of an order of disposition removing the minor from the child. So why there is this confusion is not as clear to me. But the reason this court in the intervening time should retain In re Hatcher, the reason it's a good rule is that it does protect both parents and children ultimately. In the main, these cases, these family law cases, result in affirmances. There are relatively few close cases. So if you took our typical case, the Department of Attorney General handles all the Wayne County cases. In fact, I was talking to our attorneys for our moot court, and I think we've had 87 dispositions, 1 reversal this past year, and I don't think that's atypical of other counties. The ordinary case we see, the evidence of neglect and abuse is overwhelming. They're tragic stories, right? If we had one of those cases before this court and there was a claim that there was a failure to give the advice of rights at the time of the plea for the taking of custody, for the adjudication phase, the impracticality of saying that issue can be raised now because it is of no moment. In almost every case, it's hard to think of a case in which an error that occurred at the adjudication phase, which was then followed by clear and convincing evidence standard of neglect and abuse being established subsequently is going to be useful, because the same evidence that's presented at the termination phase will be available to the department on remand. All of these cases. The exceptions are the cases where there's actually a claim from the termination hearing itself. But in all of these cases, you're going to, if there is an error at the adjudication phase, at the custody phase, that says nothing about the quantum of evidence that's been presented at the termination phase, all that's happening is we're delaying the adoption by 18 months because the termination is just going to ensue on remand. Because this is really supposed to be a practical rule. Everyone has an incentive. If there is an error that occurs at the adjudication phase, at the time of taking custody, that error be identified immediately. It is a radical change in a parent's relationship to the child, because now the department, the state, has ultimate custody of the child. If there's an error that's occurred there, everyone should be moving as fast as possible to correct that error. And if it's ultimately an error, though, that doesn't affect the termination process, it's a little like, I think the best analogy would be insufficient evidence at a preliminary examination for a criminal case. There can be an error, but if it's not going to have any real practical bearing on the outcome for the parent, no one is served by delaying that process. In other words, In re Hatcher, this is the paradigm case for In re Hatcher. It's where there is a procedural error that occurs during the plea stage. The idea of going back...
Mr. Restuccio, then why do you need the collateral bar rule? If it's, I mean, why wouldn't the traditional appellate review doctrines take care of these issues? Why do you need this rule that doctrinally doesn't really map onto these proceedings? Like,
frankly, I don't. How the rule is termed for me is not the critical piece of it. In other words, whether it's called In re Hatcher or ordinary appellate rules, if you have a right to take an appeal and you don't take that appeal, and then there's a subsequent termination, you're not going to be able to raise claims from that initial decision.
Same way a trial where there's sufficient evidence overcomes any problem in a preliminary exam, right? I mean, we have
right,
we have models in the system. We don't need a collateral bar rule to do some extra work.
For me, that's what I think, though, In re Hatcher was all about, was that very description you're giving. So for me, all you're telling me is that In re Hatcher reflects ordinary rules of appellate practice, that if you have an error that can essentially not be cured, you're not going to be able to raise it in a subsequent proceeding. I think they dovetail. But for me, in other words, you're saying this is a doctrine separate from it. Once, in my view, once the court rules provide a right to an appeal, they've created the separation. And they then make it appropriate. I think In re Hatcher reads in a very commonsensical way because it treats it as a different proceeding, because it emphasizes the importance of the initial custody decision. If anything, it emphasizes the importance of any errors being identified as quickly as possible and being rectified. I think that separation, if anything, emphasizes the importance of both parents and children of correcting errors immediately. So, in fact, I like the fact it is within this structure, because it emphasizes the distinction, the change that occurs for parents at the time in which they lose custody of their children. But ultimately, I'm not wedded to the characterization as long as the substance is the same. As long as, in our ordinary case, where someone makes a mistake at the procedure at the adjudication, then they're not 2 years later going to get it reversed, so we have to go back and then just re-terminate and then delay the adoption by 18 months.
It sounds like you and Mr. Sankaran will be able to go meet in a room and come up with some good rules to solve all these problems. So, I'm very optimistic about where this is headed.
Yeah, so for me, the critical component is to correct the court rules. I mean, to make them clear, I think that's perfectly fine. I want everyone to be on the same page. But at the same time, I think that the In re Hatcher rule makes perfect sense. And in fact, it's predicated on the expectation that parties understand their rights and are being informed by their attorneys of their ability to bring an appeal if they wish to. But for me, though, the way it works in practice is everything, because these are practical rules to make sure that litigants aren't bringing these claims in a tardy way. If there's nothing further, thank you.
Thank you very much.
Thank you.
Mr. Restuccio, are there any further questions? Okay, thank you for the... I'm sorry, you?
Yes. I'm David Delaney, the guardian ad litem.
Oh, I'm sorry, okay. And
David Delaney, guardian ad litem. I wanted to provide the court a brief summary of my practice areas. I think it would benefit the court. I'm not very accomplished, so it won't take very long to cover those.
could you try to take no longer than 5 minutes, please?
I can go fast. While I'm a real estate practitioner, I've been involved in court-appointed abuse neglect cases for 28 years, first as a prosecutor representing DHS, and now in rotation with the court-appointed contract on behalf of mothers, fathers, and as a guardian ad litem. So I don't think I have a dog in the hunt either way. I do think it'd be a mistake for this court to overrule Hatcher in this matter for two reasons. The first is the rules of evidence, and secondly is the fact that most of these children are in foster care. So, for example, if you allow the appeal of the adjudicatory phase to occur after the termination, then you're going to divest the court of jurisdiction. And the case will be remanded and will start over again. And if it's 3 or 4 or 5 years down the road, the rules of evidence apply at the adjudicatory phase, meaning that we have to find the daycare provider, the psychologist, the DHS workers, and things like that. If you reverse a termination case where hearsay and the rules of evidence generally don't apply, and there are exceptions where they do apply, you have less of an evidentiary hurdle. And that ties into the fact that in most of these cases you have a child that's been in foster care for a substantial period of time. I've met Jessica a number of times. She's been in foster care for going on 4 years now. This case actually began in 2013, so we're in our 5th year of this case. I hear that there are, due process concerns and things like that. Beginning in 2013, we've probably had 30 hearings in this case, and I think that the due process rights of the parents were well protected. I want to address one issue raised about adjudicatory appeals. Justice Wilder, in 2012, I was counsel for mother in a 3-day jury trial. Hearsay was admitted. After the jury trial and after the first dismissal hearing, I took an immediate appeal. Because of the hearsay, Justice Wilder and 2 other judges reversed the case. It went back down to the trial court, and the Department of Human Services dismissed the case because they didn't have the hearsay anymore. But there's an example of an adjudication appeal where Hatcher worked. You get a glove on the fact that the court has subject matter jurisdiction and you address it early. If you wait, had we waited in that case, the 3 or 4 or 5, 6 years in this case, that child would have continued in foster care. So it allows the parent and the child to have an immediate adjudication of that issue. And I see no reason to disturb Hatcher in this case. We knew about the rule then, and we pressed that rule. And it allows that issue because there's a child in this case. I heard the UII case before and other jurisdictional cases. That's the exception that you're looking at. You have children, and time is of the essence in those cases to have those heard. And I would invite questions on that issue. I also wanted to address the home visit and the court meeting with the child if the court wanted to address those 2 issues. I was present, and I've been to this home a couple of times in this case. And, even the blogs are talking about the judge just going to this house and violating due process with a search warrant. That's even in one of the briefs here. That really didn't happen. We were probably in that home 10 or 15 minutes. We weren't there to see if the carpet smelled of urine or any fact-finding process. There were 5 lawyers, including the judge, the parents, and their 2 older boys in the home at that time. I think that the court wanted to get an idea of what the home looked like. Where was her bedroom? Where was the bathroom? How did she navigate with the wheelchair? But none of that evidence was used to terminate their parental rights in this case. The second issue is...
But that's unusual, isn't it? It's a little bit unusual. I mean, that's in your years of doing this, how often has that happened?
Probably never. But Judge Cooper is a very, very good probate judge. He was a custody lawyer for many years. He's very tied to children.
How do you know it wasn't used in the termination decision? I mean, he said it was a very close case, then he went to the house, and then he just tipped it one way. I mean, how do we know? I mean, do we know what was in his brain when he decided that?
Well, we don't need to know that because we have an extensive record in this case. We have
Except we don't have a record of what he witnessed and saw when he was in the home.
Right, but that's not reflected in his decision. He didn't say... he
but
does
it's in
say...
his head, and he's the one making the decision.
Yeah, but...
It's sort of a metaphysical question. But all right, I get your point. Thank you.
No, and I understand we can't see inside of his mind, but there's independent evidence in this case of the medical neglect and the services that we provided that the parents weren't able to adopt. But what
Is it
could he have
unusual,
seen?
though, that, Counsel, is it unusual that you would have one of the children being taken away and not all of them?
Well, the other 2 children were adults. I don't know that...
I understand that, but
Yes.
But the point is that it is a little unusual that the focus was on this one child, though, wasn't it?
When you have special needs the way that this child did, the spina bifida in the third degree of the kidney disease, certainly. And that, Justice Bernstein, you've tacked on to a really critical issue that was the subject of the basis, in my opinion, of the termination, and that is the parents who are good people were unable to absorb the special needs of the child, and because of that, they put her at risk of her health, safety, and welfare.
But wait, that's okay. I know that we really all want to go, but
But now you touched on it. You just
But
did
I'm
it.
sorry.
That's it.
Yeah.
No.
Everybody buckle in.
I guess I get more than 5 minutes.
well, you might
lecture?
it might be a little while. But
All right, I'm ready.
But okay, so now I really have to ask you some questions. Is there a separate standard then that you would apply for children with special needs as it pertains to being able to remain with their parents?
No, I would not do that. I'm not distinguishing that in this case, but you do have to, as a parent, pay attention to that issue because of the fact that if it was not addressed.
How do you pay attention to that issue?
Uh,
How, as a parent of a special needs child, I don't mean to give you a hard time, but I mean, you're a GAL. I was a GAL when I was at Northwestern, and I just think that I just need to have an understanding of this.
Yes.
When a parent has a special needs child, isn't it fair to say that they pay special attention to that special needs child all the time?
Sure.
And so how is it the state's, is there a higher burden now if you're a parent with a special needs child to care for your child, where the state is going to come in and take your child? I mean, explain to me what you mean by all this.
Right. I don't have any different burdens for a special needs child, but Jessica had to have, there were missed medical appointments and her prescriptions weren't filled, and that increased her risk.
I get that, but is that, so let me ask you a question. What if you have an able-bodied child? I'm not trying to give you a hard time, I'm just trying to understand your position.
No,
If you have an able-bodied child and the parent misses a doctor's appointment or whatever that issue is, does the state then have that same standard that they would apply?
No, I mean, that's different because if you're not providing your vitamins or getting them for a well checkup and things like that. And your questions I view very sincerely, Justice Bernstein. In this case, the department and other agencies were providing assistance to the parents to make sure that, to remind them that you have a special needs child. You really can't go for a prolonged period of time without getting her to a doctor's appointment, filling prescriptions because of her kidney disease. And if they had not
But
addressed
the parent
those things-
doesn't know this. The state has to remind them. Like it's now the state's. You don't think that the parent is I'm just talking now in general, because you're applying it to this case. You think that now it's the state that needs to tell. Like, would my parents need to be reminded that I was blind by the state? Like, is that something that they should be? Is that something that my parents should be reminded of, or do you think they're cognizant of that by themselves?
No, I don't think they need to be reminded of that. And I just want to indicate that what got you and I on this discussion was the suggestion that the court did a fact-finding process at the mobile home, or did a fact-finding process by interviewing the child. I wasn't looking at defending or addressing the merits of the termination itself, but we're here. And I think that the state didn't go looking for this type of evidence. In fact, they started the case in 2013, thought that her needs were being addressed, and closed the case. So the state moved on. And I'm not an advocate for or against the department. Tomorrow morning, I'll have a case against the department as a counsel for the mother or the father. So the state did intervene and then backed off. And then the school was reporting, and there were other issues coming up relative to the health of the child.
What's the standard that we need to look at if we're going to get into this? What's the standard I need to look at for children with special needs? If a parent has a disabled child, are you advocating that there is a different standard that has to be applied to a child with special needs than that of a child without special needs? So if you give birth to a child with disabilities, are you now at a higher standard than someone who doesn't have disabilities?
I've never argued that or said that. And again, what started it was one of the justices asked me, and it might have been you, Justice Bernstein, that, well, why weren't the other children removed? Why was Jessica addressed? And I think the other children were adults at that time, the two boys. But I don't see a distinction. The standard is risk of harm. Is there or is there not risk of harm to the child? And I don't single this case out because of her special needs. We have a number of cases like that. We can have risk of harm where we don't have those issues. And it was never on my radar screen, Justice, that I made that distinction in my mind. But when asked about what the basis was, it's in the court record, those were some of the issues here that were addressed. Was that Jessica had sensitive medical needs that the court found were not being met, but I don't make a distinction between that issue and a child that doesn't have those issues. I simply don't.
I'm going to show mercy to my colleagues and let you submit the case.
And the final
Mr. DeLay?
statement I wanted to make, Justice, was that...
I think you've gone a little bit beyond your 5 minutes, so
Okay.
I'm going
Thank
to
you very
cut you
much.
off here, but we appreciate your participation in this case, both at oral arguments and in your filing of the amicus brief. Thank you very much.
I thank the court.
Did you have something further you wanted to say, Mr. Sankaran?
I can see that Justice Zara is ready to leave. This has been a long argument. Two very, very quick points I wanted to make.
Please proceed.
Responding to Justice McCormick's question about visiting the home and the impact, we actually do know the impact that it had because the trial court, in its written opinion, stated, even when the court viewed the situation, it is not where a person with spina bifida will thrive. I'm not sure how much more straightforward the impact of the fact that he relied on his observations could be clearer in terms of the written opinion. Second, I just wanted to briefly say that termination and adjudication proceedings are very different under the law, and that the way that the structure of the juvenile code is set up is that a termination presumes a valid finding of unfitness at the adjudication stage, such that in Michigan, we could terminate someone's rights based solely on compliance with services. Right? So if someone has an adjudication finding that they use drugs, and this is how many of my trials are at the termination stage, if they didn't show up to drug screens, that in and of itself, you don't have to reprove the initial adjudication stage. So this idea that you will always have evidence to satisfy the adjudicatory standard simply because you have a termination finding, it's simply not true because the type of evidence used to prove the different determinations are quite different. With that, if there are no further questions, I would ask the court to reverse Hatcher and reverse the trial court's decision in this case.
Thank you, counsel.
Thank you.
Case submitted. We stand in recess, or we stand adjourned until November.